My name is Aisling Ez. This is
Tisha Desai. We're representing the University of Melbourne, Australia.
Welcome.
Yes.
Begin.
At its core, this case reflects a deep ethical question of right and wrong behaviour in the practice of garment manufacturing. It addresses issues of right and wrong, good and bad, and asks us to consider what is morally acceptable and desirable in terms of human behaviour and treatment. In practice, and especially in the garment industry, ethically sound behaviour must respect the intrinsic rights of all human beings. It must respect the right of workers to a fair and decent wage, to quality working conditions, and to acceptable treatment and conduct by employers. I want to just outline the key elements of our case before we go any further. Lisa is a partner at Exxon, a fictional global professional services firm, and she has been separately contracted by the Australian Human Rights Commission to report on the processes of Glamour's manufacturing factories. Lisa is also aware that Glamour is Exxon's third largest client. Lisa completes her draft review of Glamour's factories, but then at an industry event under the convention of the Chatham House Rule, finds out that Glamour is subcontracting work to another factory, the Red Factory, in which there are questionable practices. Lisa now has a decision to make as to whether or not to disclose this unsubstantiated information to the Australian Human Rights Commission. Lisa is grappling with an issue now faced by the majority of the garment industry, who outsource manufacturing to developing or underdeveloped nations like Bangladesh. The majority of these garment factories are hotspots of unethical production, subjecting their workers to unfair treatment and abuses. The questionable practices of the Red Factory, although not specified, are also presumed to be unethical, whether in their treatment of workers or in their endorsement of child labour. It is this blatant abuse of the right of the Bangladeshi worker which makes this dilemma today an ethical one. This dilemma centres upon whether the benefits Glamour and Exxon gain through the manufacturing operations of the Red Factory are worth the violation of basic human rights. Which we have concluded they are not. We have taken the position that in disclosing this information to the Australian Human Rights Commission, Lisa is ethically justified and her actions are defensible. The scope of this presentation today will cover the different ethical lenses that we can view this case from, the amount and type of tangible good and harm involved in the problem faced by Lisa and Exxon, and how the actions of Glamour are not ethically defensible, the amount and type of tangible good and harm involved in our solution, the existing conflict of rights between involved parties, and finally, how our solution is ethically defensible and acceptable.
There were different ethical perspectives to be considered regarding how exactly we chose to tackle this case. One ethical lens focuses on the consequences of actions and the greatest good for the greatest number of people. This perspective can certainly be applied to our scenario as it allows us to weigh up the rights of all parties involved by aiming to minimise harm done. However, the ethical lens we chose to utilise focuses on the righteous action. Rather than attempting to make a decision based on potential consequences, this lens puts an emphasis on doing the right thing, and in doing so upholds human rights. Our solution is rooted in the fact that it is inherently right to put an end to exploitation and abuse, regardless of ramifications there might be for more powerful parties. Our ethical stance is reflected in Article 23 of the UN Declaration of Human Rights, the International Labour Organization Conventions, and the UN Guiding Principles. I will now address the good and harm involved in our ethical dilemma. At present, there are many parties that benefit from the current situation. There are significant financial benefits for both Exxon and Glamour by operating in the Red Factory, as manufacturing costs are kept low and therefore profits are high. Exxon is retaining Glamour as a client, bringing in $50 million annually, and has several employees engaged with the client. Numerous Bangladeshi people are provided with employment and income as a result of these operations, no matter how questionable they may be. However, in terms of harm, these practices mean that workers are potentially being exploited and having their human rights violated. Glamour and Exxon are not cooperating with the transparency and honesty expected of global corporations. Defining ethical business practice to be the fair and equal treatment of workers means that it is reasonable to conclude that Glamour have no ethical right to subcontracting work to the Red Factory. In doing this, they are engaging in the unethical business practices that are completely unacceptable in today's world.
The solution that we have come to upholds the expectations of ethical business practices in the 21st century and defends fundamental human rights. In this context, ethical business practice relates to the activity undertaken by businesses that does not compromise the rights of individuals for financial gain. Nevertheless, we acknowledge that there is still both harm and good in our solution. Although there are short-term financial losses endured by Glamour and Exxon, the potential loss of Glamour as a client, the potential retrenchment of employees at Exxon, and a potential loss of trust in the wider industry, these are relatively minor losses when compared with the blatant abuse of human rights. Our solution not only upholds the rights of these workers in Bangladesh, but encourages transparency, ethical business conduct by both Glamour and Exxon, and sets a precedent to be followed. On top of this, it strengthens Exxon's reputation as an industry leader and could potentially lead to long-term financial benefits for either of these parties. In regards to the harm done through our solution, these short-term financial losses are a result of either Glamour having to be dropped as a client or Glamour having to increase their manufacturing costs. Exxon employees engaged with Glamour may well become redundant should they have to drop Glamour as a client. Breaching expectations of the Chatham House rule may result in animosity between Exxon and other corporations. We acknowledge that our solution is not ideal from a business perspective, but allowing this type of business engagement is not ethically defensible. We cannot and simply should not defend Exxon and Glamour's actions on the grounds that it brings in a revenue stream and sustains their financial durability. By disclosing this information, Lisa is not limiting her decisions to business considerations, but considering the global impact of her actions. She is defending the rights of those who cannot defend themselves in a world where power and corruption silence the most vulnerable.
Several stakeholder reputations are at risk here, and therefore it's crucial that we weigh up the conflict of ethical rights. This allows us to treat all parties equally and makes our solution even more substantiated. This conflict of rights exists between the rights of the Red Factory workers and how Lisa perceives her responsibility to Exxon as her employer and Glamour as their client. On the one hand, Lisa has a right to protect Exxon's interests and reputation as well as that of their clients. From Lisa's perspective, it is her right to put Exxon's interests over that of a party she is only indirectly associated with. She has a right to value the jobs of Exxon's employees over unsubstantiated information that, in reality, could be inconclusive. On the other hand, the workers in the Red Factory could potentially be underpaid, overworked, subject to abuse and unsafe working conditions, or be victims of child labour. It is their ethical right to be treated with respect and be given due autonomy in their own working environment. It is not ethically defensible for corporations to continue to put their financial benefits over that of inalienable rights of vulnerable factory workers. We have concluded that our solution is both ethically defensible and acceptable. By reporting this information to the Commission in both an objective and neutral manner, Lisa is not compromising her obligation to either party. We have advised that she suggests to the Commission that they extend the scope of their review to include subcontracted factories based on information she's heard, simply as a means to gain a more conclusive understanding of Glamour's manufacturing processes. Through this, we are not jeopardizing either party's ethical rights. We are simply appealing to the core values of the Australian Human Rights Commission, who strive to respect, protect, and remedy the rights of human beings.
This case is just another example of large corporations stepping on the toes of less powerful parties and capitalising on their working environment, which denies them access to their fundamental rights. In this day and age, we can no longer allow this to happen. It is a matter of moving away from a world dictated around money towards a world where corporations are more considerate of the ethical implications of their actions. Whilst we acknowledge the harm endured by certain parties in our solution, we can defend it because this is ultimately the right thing to do. Thank you very much.